Today is the punishment phase of this trial, and except for jury selection, obviously, it pretty much procedurally will be the same as the regular trial was. So there will be opening statements, some evidentiary testimony presented to you, this type of thing, and some closing arguments, and I'll charge you on the law as it relates to the punishment phase. All right? So, may proceed.
Trying to say without having any opening statement as such, because the nature of this part of the hearing, but we would, to put on the record, I think procedurally, is that at this point in the trial, the state is relying upon two aggravating circumstances. Number one, the defendant knowingly created a great risk of death to two or more persons other than the victim murdered during the act of murder. And two, the defendant committed mass murder, which is defined as the murder of three or more persons, whether committed during a single criminal episode or at different times within a 48-month period, and would ask the jury to consider as part of the proof in this case the evidence that was presented during the guilt-innocence phase of the trial. And with the court's approval, we would now ask to be allowed to call victim impact witnesses.
Good morning. I want to start by saying that although we disagree with your verdict, we fully respect your decision and appreciate the work y'all put into this case to this point. We just see things a little differently, but we nevertheless respect what you've done and appreciate the work that you put in on this. Now we're going to a different phase in this case, and you're going to have a choice. You're going to have a choice between two options, and those options deal with what's going to happen with Travis Reinking from this point forward. One of the choices that you're going to have is to sentence him to life imprisonment with the possibility of release at some point. You may or may not have been aware of this at this point, and the jury instruction will say this, but that decision means life imprisonment with the possibility of release after serving 51 calendar years in prison. So what you've done by your verdict is, at a minimum, you've already sentenced him to a minimum of 51 calendar years in prison. At his age, you can ask yourself, do you think he'll ever make it out, even if he had that opportunity for parole? So one decision you have is, do we sentence him to life in prison with the possibility of release after 51 calendar years, or do we just say life in prison without the possibility of parole? That's the two decisions, the two choices. In factoring in what your decision should be, as the state said, one half of the scale is the aggravating circumstances that they believe they have proven in this case. On the other hand, we have what are called mitigating circumstances. Now, the proof that you can consider in the aggravating circumstances and the mitigating circumstances can come from whatever you see today, and can also come from whatever you saw in the trial itself. So we don't have to come in here and put on more evidence. And I'll tell you right now that we're going to be relying on all the mental health proof that we put on in the trial. You would consider that just as if we spent 2 days doing the same thing again. So anything that you have heard, seen, observed, that from the beginning of this trial up and through today, you can consider in determining whether or not an aggravating circumstance or a mitigating circumstance applies in this case. We believe that when you weigh that evidence, you're going to find 5 mitigating factors. They mentioned the 2 that they believe they have proven. We're going to mention the 5 that we believe we have proven. Those 5 that we believe we have proven are: the defendant has no significant history of criminal activity. You've heard about an arrest, and that would be prior to this incident, but you've heard about the arrest in D.C. for what he did there. But we think that applies in this case. The next mitigating factor was the murder was committed while the defendant was under the influence of extreme mental or emotional disturbance. I think that's as clear and absolute as it could possibly be. The murder was committed under circumstances what the defendant reasonably believed to provide a moral justification for the defendant's conduct. He believed that moral justification. The capacity of the defendant to appreciate the wrongfulness of his conduct or to conform his conduct to the requirements of the law was substantially impaired as a result of mental disease or defect or intoxication, which was insufficient to establish a defense to the crime, but what substantially affected his judgment. These four that I've read so far, there's a fifth one, but these four come from our statutes that said these are the legislature believes that these are statutory mitigating factors that you can consider. We no longer have a burden of proof to prove these by clear and convincing evidence. In fact, you can find this on your own. We don't have the burden of proof on that. You can find this on your own. And so those things basically in a nutshell means that although you apparently didn't believe that our mental health proof was enough to rise to a defense, it certainly can be enough to sentence him to life with the possibility of parole after serving 51 years, as opposed to life without the possibility of parole. The fifth mitigating factor is any other mitigating factor which is raised by the evidence produced by either the prosecution or the defense at either the guilt or sentencing hearing. That is, you shall consider any aspect of the defendant's character or record or any aspect or circumstance of the offense favorable to the defendant which is supported by the evidence. That means anything else that you individually find to be mitigating in this case. Some of you may find some of the mitigating factors exist. Some of you may disagree. When it comes time to weigh these, some of you may give great weight to some of these. You may give great weight to his mental health situation in determining what the punishment would be. Some of you may not be as moved by a particular mitigating evidence. But what's happening here is the 12 of you are basically making your own individual decision as to weighing out the statutory aggravators and mitigators and deciding for yourself, should Travis be punished by being sentenced to life imprisonment after serving 51 calendar years in the Tennessee Department of Corrections, or do we need to up that to just say life without parole? And each of you make your own individual decision with that. So after you hear the proof today, and at the end of this sentencing hearing, you can consider everything you've heard from last Monday morning all the way through today. You can look at the statutory aggravating circumstances, look at the mitigating circumstances that will be in here, and each of you individually get to weigh your decision as to what is his punishment from this day forward. And obviously, we are asking you to sentence him to life imprisonment with the possibility of parole after serving 51 calendar years in prison. Thank you.
Go ahead, President.